Welcome back to Day 3 of the 2022 Nuremberg Forum, the International Criminal Court 2002 through 2022, a court in practice. Before we proceed to the first panel of the day, panel 4, I will ask my colleagues to post the motion of this panel to the screen. There it is. Okay, the Slido motion, in fact, this was flagged yesterday by Judge Fernandez, anticipating it. Acquittals are perceived by the international community as failures of the ICC, agree or disagree. A reminder, you can vote on this by scanning the QR code at the back of the brochure with the camera of your mobile phone. The polls are now open, so you can vote anytime throughout the panel. And a reminder, if you ask a question on Slido, you can submit it anonymously or in your own name. And now I will introduce panel 4 with a substitution, in fact, because Betty Murungi is not well today. So in her place, we have Dr. Athaliha Molokomme, who will chair the panel. She spoke yesterday as well. She is the Attorney General, or was rather, the Attorney General of Botswana, and she is currently the permanent representative of Botswana to the UN in Geneva and ambassador to Switzerland. She will preside over a very accomplished panel, including Chief Charles A. Taku, who served as president of the ICC Bar Association from 2017 and has been lead defense counsel in cases at the ICTR, the Sierra Leone Special Court, and the ICC, as well as Judge Ivana Hrdlichkova, the president of the Special Tribunal for Lebanon, participating remotely, and Dr. Pham, assistant professor at the Harvard Medical School, who has over 20 years' experience assessing the impact of mass atrocity crimes on the population and how transitional justice mechanisms impact social reconstruction and peace building. I would like to welcome all of you, please, to the bench. So I give you the floor. When you're ready. When you're ready. Take your time. That is a good question, and we're going to see if we can solve that. But I think if you proceed, and yeah, you can give the floor then to Judge Hrdlichkova and then to Dr. Pham, and then if he comes, we'll slot him in when he arrives.
Thank you very much, Jennifer, and good morning, colleagues. First of all, welcome to Day 3 and the 4th panel of the Nuremberg Forum. As you have heard, I am the substitute player for the team this morning on behalf of Betty Murungi, who's unwell. She has a sore throat. It's not too bad, but she thought it was better to rest her voice rather than be here. So to the Nuremberg Principles Academy, of which I'm privileged to serve as a member of the Advisory Council, I'd like to thank you for convening the forum in the first place, which I'm delighted to attend after a 3-year absence due to COVID, and earlier in last year, even couldn't attend virtually. So I'm pleased to be able to fill in on behalf of Betty, but I must tell you that Betty's absence this morning will deprive you and the conference of her wide-ranging experience in this field, as you'll have seen from her bio, which I must say doesn't do enough justice to what Betty knows on issues, especially of transitional justice. So do forgive me. The good news is that I will not take up much of your time making introductory remarks, because I don't know much about the subject, but I guess I know enough to be able to conduct the proceedings. So there will be more time for you in the room in court 600 here, and for our many participants, I hope, who are online. It's a pleasure to have you all here on a rainy Saturday morning in Nuremberg. I'm sure some of you will have had something better to do than sit in court on a Saturday morning. This panel is expected to discuss a number of questions which were shared in advance with the panelists. Let me quickly share them with you. Firstly, the first question is, when looking at the Rome Statute's preamble, what goals are central now, particularly to protect the rights of witnesses and victims? Secondly, how balanced against the rights of the defense? Third, how are these goals measured against the overarching goals of securing cooperation, ensuring effective prosecutions, and contributing to prevention? Fourthly, have the challenges to witnesses and victims' protection and participation been addressed? and what challenges persist? Concerning reparation, a fifth question, what has been the impact on victims and their communities? What have been the challenges, sixthly, connected with convicted persons in the post-sentencing period, and how have these challenges been addressed? A final question is whether what acquittals mean for the fairness of the original trials and how these can be improved. I believe this is related to the question that you've been asked to vote on online. The expectation is that our distinguished panelists will draw together remarks based on 5 or 6 major points, whatever number they bring based on their experience, relying on concrete examples and data that supports their arguments. I'm here with Professor Pham, who's been introduced, and she will address questions 1 and 5, but I would like you to feel free to address any of the other questions. I'm told you have 15 minutes, and you have the floor. Professor.
Thank you so much, and thank you for coming here on a Saturday morning, too, and still here. First, I want to thank the International Nuremberg Academy Principal for organizing this event and inviting me here. It's been an incredible 2 days of reflections of the first 20 years of the International Criminal Court. I've been asked to reflect on what's the impact of reparations on victims and their communities, and I think those who know some of my work, I promise I won't cite a lot of statistics here today. I'll address these questions in 3 parts. I will highlight the data from over 200,000 individual surveys of survivors in affected community we've conducted over the last 15 years to illustrate that victim expressed desire are not inconsistent to the preamble of the Rome Statutes and the goals of International Criminal Court. I will also note the challenges of meeting the needs and expectations of survivors. I will consider the current state of the ICC reparation program and discuss why it's not possible to answer these questions for the ICC yet. And I will discuss cases beyond the ICC, notably the Colombia reparation program and the extraordinary chamber in the Court of Cambodia, or the Cambodia Tribunal. Finally, I will discuss the importance and the value of monitoring and evaluations of the ICC implementation process and the impact both internally and externally. Before I go to the first point, I can't reiterate enough the fact that the ICC is the court of last resort, meaning this is the victim's last hope of justice. And the fact that the Rome Statute put victim at the core of the ICC mandate is a huge step forward toward global recognitions of the rights of victims in this situation. So let me start with the first point. Based on the surveys of victims we conducted over the past 14 years in some of the ICC situation countries, we found that there's consistent response when we ask what should be done for victim. That is beyond criminal accountability. First, peace and security. Second is to restore the ability to access basic need such as food, water, and education for their children. Thirdly, to recognize the harm they suffer and restore that has been lost and absent. And finally, the need to know the truth. What happened during the conflict, what exactly happened, who was responsible, why they committed the atrocity, and what could have been done to prevent it. The expressed desire are not inconsistent with the preamble of the Rome Statutes and the goals of the International Court. The court investigation findings and documents could help contribute towards allocating responsibility, acknowledging the victims through victim participation, providing restorative assistance and reparation, and finally, creating a historical records of what happened through archiving and preserving the court records. These are really important ways that the court can contribute toward those desired. However, I would be short-sighted to think that the court automatically meets these needs. In fact, the evidence is largely about the gap between what the court can deliver and what the survivors expect to be delivered. We have seen, for example, There are very high expectations raised by the amount mentioned in the reparation order compared to the narrow scope of the convictions and the impacts in community of exclusions of individuals having suffered similar harms. There's also data to suggest that survivor can be re-traumatized at the idea of being excluded from reparation programs if they were not victims, as if they were not victims enough. This may be justified legally, but there are severe consequences for those concerned. We've also seen confusion and lack of clarity as to what survivor can expect in terms of reparations. Elsewhere in Cambodia, for example, we are also seeing how the closer the survivor are to the proceeding, the less positive they are. They gain more intimate knowledge and the limitations of the court. This, too, the ICC have not been able to manage expectations well enough, and this fact alone could undermine its potential impact. To the second part of the current state of reparations. So my first point was the potentials for reparations and the ICC in general to meet the needs of survivors. But the effective challenge of managing expectation. This brings me to my second point and the importance of managing expectations and the perceptions of judicial process to maximize its impact. Currently, the trust funds for victims at the ICC has 5 reparation proceedings in Lubanga, Katanga, Nandanda cases in DRC, Amahadi in Mali, and Onwin case in Uganda. Implementations of the reparations 4 awards are ongoing, and thus no impact data are currently available. If I can turn away from the ICC for a moment and look at the reparation program in Colombia, there are important lessons to learn. We did a detailed evaluations, including surveys of thousands of survivors and participating in the reparation program. First, we found a lack of evidence directly linking to those who receive reparations with improvement in the direct outcomes stated by the government, such as alleviating physical harm, emotional and moral damages, and contributing toward social economic stabilization. I should note that this was done right in midst of reparations implementation, so only half of the victims have received reparation at that point. However, those who received the reparation process as fair and effective were more positive about the state and the government in general, which in turn influenced their civic participation and social engagement with the community. We also found more generally that the process of delivery and the perception of that process are important consideration in designing, implementing, and assessing the impact of reparations. In effect, all this resonates with the idea that justice not only must be done, but it must be seen to be done. So in this case, the perception of reparation being perceived as effective, or reparation being seen, is just as important, if not more important, than the reparation itself. This emphasized the important role of effective communications and outreach in the potential impact of transitional justice programs and policy. But this is not to say that reparation impacts are merely communication efforts, but rather that reparations without engagement and communication is less likely to be effective of achieving system-level impact. Secondly, we found stronger evidence that reparation contribute to enhance vertical relationship, that is, between survivor and the state, rather than the horizontal contribution, for example, coexistence. This suggests that individual reparations may be better at improving relationships between citizen and state, and the individual who receive reparations, but is not the best for restoring relationships between individual within community. Finally, to the importance of monitoring and evaluations and the need to devote sufficient resource to it. If we believe that the Rome Statute was an innovative treaty and that the ICC is an innovative institution with goal to make global change, then like any innovation, we need good research to design its universal translation. Yesterday, Judge Sylvia Fernandez argued for the standardizations and the guidance on the applications and the translations of the Rome Statute. However, to develop these standardizations and guidance, it needs to be backed up by data of best practices. So we need systematic evaluations, monitoring, and implementation science to guide strategic, tactical, and technical decisions for its translations and implementations. On the same vein, we also need to agree on common framework on how we assess the impact of the ICC. Finally, the court itself needs more resources to conduct its own evaluations. Currently, there's only one staff the court has as core functions of M&E, and she's based at the Victim Trust Fund. Also, importantly, the court needs to collaborate and coordinate with external experts to conduct independent evaluation of its process as well as its impact. In short, my message is that the ICC is in a unique position to address the needs and expectations of survivor, but the impact is not simple to achieve and relies importantly on the process of how its implement its proceeding and how the process is perceived. Impact is most likely when considering vertical relationships between survivor and institution rather than aspects of coexistence. However, there's strong need to improve the evidence base around reparation. Thank you.
Thank you very much, Professor Pham. Chief Charles Taku, are you ready to make your presentation?
Yes.
I don't want to take you by surprise since you just came in here. If you're ready, please go ahead. You have the floor.
Thank you so much. I sincerely apologize. I took some medication and it put me to sleep, but I started running to come. That said, a central objective of the preamble of the Rome Statute is to conduct effective prosecutions in order to protect and to prevent atrocity crimes against the delicate mosaic uniting our common cultures and in order to protect the central values of our humanity. And as we all know, without the protection of the witnesses and the victims coming before the court, there will be no cooperation, either from the witnesses or from the states in which they reside. As you see, the preamble of the Rome Statute recognizes culture. It is therefore a foster child of multiculturalism. Very often, as we see in African situations, the witnesses, the victims, and the accused, they all come from the same community, sharing the same cultural values, sharing the same existential interests, and sharing the same values. Let me quote an example of the actually in northern Uganda that we see in the situation in Uganda. For them, Mataput and Cheng are very central values who are common to them. Mataput has kept or helped actually to rebuild their lives and reclaim their humanity. Millions of them. even though only one case so far has come before the court. And these witnesses coming from there actually to testify, and the victims coming before the court are able to do so because they were protected or they underwent the matter of put. And they expect that when they're accused, irrespective of the outcome of the case before the ICC, when they return to the community in order to be accepted, they must undergo the matter of put. It is central to your well-being. And therefore, these people before the court expect the addition to the protective measures which the court will give. The court, they themselves, for their society to accept them back, they must undergo this alternative justice mechanism. It is central to them. Now, this central mechanism comes before the court because of what we call cultural sensitivity of the individuals. They testify about it extensively. They go back to it many more times. And if the protective measures given, of course, some of them, protective measures, anonymity in the courtroom, some of them, in order to caution the effect of the re-traumatization of the experiences. In addition to this, there must be effective cultural sensitivity in the food they are given, in the way they address, when they come there in winter. They must know they come from extreme hot climate, and the way they relate with each other, and the way they testify before the court, and the way that the interrogations or the evidence take place in the courtroom. In other words, it's part of their humanity. In fact, it's their humanity and their human dignity. With the accused persons, we discovered, and I do not want to go deep into the cases because of some ethical reasons that we all know that I'm not supposed to discuss, get into the cases which are before the court. But one thing is obvious. We discovered one of the cases, in one case, a case of first impression in many reasons, because we now have the notion of victim-perpetrator. He is a victim, but also a perpetrator. And when we're talking about victims before the court, we also have the notion of dual status, victims, witnesses. In this particular case, I also have different witnesses who are also victims. In other words, there's interrelation between these individuals who are there, each taking one, sharing something. And we have what we call insider witnesses also, who might have been involved in the crime themselves, but in order for justice to be seen to be done and the trial to be effective, they decided to play another role. But take note, as I said, many of these other victims who are not participating victims may never have any other source of justice before the ICC, but they are able to rebuild their lives and their communities because of matter of put. Professor Tim Allen, Linda Carter, and many others have said about this. And it's because of matter of put that there was an original and continuing push back by the communities of northern Uganda, even though international justice is also necessary because they also share an interest in the crimes committed in that situation country. I earlier said the preamble is a foster child of multiculturalism. Now, let's talk about the convicts, people who have been convicted, and are under discussion of the court. The Rome Statute framework places the supervision or execution of judgment in the hands of the presidency of the court. And the president of the court requires the objection of detention or imprisonment for countries must respect the Mandela rules. In other words, the fact that they have been convicted does not mean that they lose their humanity, they lose their rights. No. the court intends that by the way they are treated in prison, countries where you have brutal regimes or communities that have taken out arms, I think that it is by arms and criminality that problems can be resolved. We now learn that it's an alternative, and the alternative is shown by the manner in which these convictions, the imprisonments, are supervised. The presidency of the ICC had supervised and had entered agreement with the Democratic Republic of Congo for Mr. Lubanga and Mr. Katanga to serve their imprisonment in the Congo. But then, the ICC has so far entered into agreement with only one country, Mali, for ICC convicts to serve their interim imprisonment. More effort has to be done if the ICC does not want to slide to the extremely embarrassing situation of the ICTRO meet, where you have 8 persons who are acquitted and persons who serve the imprisonment who are stateless on the very watch and supervision of the civilized world, the United Nations, and the court. And their lives are on the balance as we talk, and yet we're supposed to be the showcase of international justice. That has not occurred. So far, the ICC is not looking in that direction. And I visited the detention center. I talked to lawyers for some of the people who are serving their sentences, and I assured the ICC, presidency, and the professional staff in the ICC, at least they're doing a good job in that regard. There are problems that they complain, which are normal problems, but the presidency has decided that pursuant to the Mandela rules, these convicts and persons in detention have a right to family rights, visitation with their families. Take note about what I said about their culture. They come from far, and the justice is taking place in The Hague. And therefore, the conditions of living for witnesses, for victims, and also these accused persons, must take into consideration their cultures, because the traumas also that a victim perpetrator in jail will suffer, the court is conscious that it's a victim, but it's a perpetrator. Or the court is conscious of that, and therefore they must be as close to their culture, their families, as much as possible. COVID and other unforeseen impediments made life difficult for everyone. And the technology put in place appeared to have changed the way we operate forever. So they had to communicate by Zoom and others with their families while waiting for those measures to be taken. And I saw some action towards bringing their families to see them, because some of their families who must not suffer, they must benefit and not suffer from international justice, not accused. Now, there's something I wanted to say about, I do not know whether the distinguished professor already talked about that, about victim participation and balancing the rights of the accused. The ICC being a court of first impression, the victim's participation is something we're struggling with. In some cases, they are perceived as playing an enhanced role of going as far as submitting evidence and doing cross-examination and putting question on the guilt or innocence of accused persons. In others, the judges clearly restrict it to submission of victims' interest and victim interest. I wanted to go quickly because I'm conscious of my time. There is a procedure which is very effective also for the defense about collective victim representation, because it facilitates expeditious hearing with the different ones, where the victims are in categories. You have the representative of victims in case they get their own counsel, and you have common victim representation where they do not. And this helps in facilitating expedition, because if every victim were to be represented, it becomes a mockery of justice. But they have been very effective. And there are many other issues. I will answer the questions on any point, but for now, because of time, I will wait for your questions. This is what I'm saying. In particular, I'm sorry, about the defense, among the defense rights, Article 67. So when we talk about rights here, the right of the defense and the rights of victims and witnesses, I think the statute talks about victims' protection, victim interest, and the right of the defense. So at the end of the day, the primacy of the right of the defense, because the defense is presumed innocent. Also, the right under Article 67 and also Article 14 of the International Covenant for Civil Rights are some of those rights that this preamble refers also to the United Nations Charter for them, because they are protected under Article 1, Sub 2 of the United Nations Charter, Article 55, Sub 3 United Nations Charter, and the entire United Nations human rights regime. They are different from those of victims, from the interest of victims and protection of victims. So when we talk about rights in the preamble and the statute and victims and witnesses, I think there are different, distinct issues. Thanks so much.
Before we continue, a small program note. Judge Hrdlichkova has encountered insurmountable technical difficulties relating to electricity in her hotel. In her unexpected absence, Dr. Philipp Ambach has graciously agreed to step up to the podium and to improvise based on his experience as the chief of the Victims' Participation and Reparations section at the ICC. So a big round of applause for Philipp for joining us unexpectedly at the podium. Thank you. Thank you. And then we'll proceed to questions and answers after that. Thank you.
Thank you so much for inviting me. So this is day number 3, the only day that I don't wear a tie, and here I find myself addressing you. I first had thought that August scholars such as Klaus Kress were a good example of not wearing a tie, but then I realized that on the day that he has to speak, he wears one. So complete failure. Thank you very much for giving me the chance to now step in for President Hrdlichkova, to whom I greet as soon, well, she can't see me, I guess, for the problems that she has. I guess I'm going to now improvise a bit and talk a tiny little bit about how the victim participation and to an extent reparations framework at the ICC has panned out so far, so that I bring it somewhere into the topic of this panel. Obviously, what I will be saying is from an ICC perspective, but I think that we can agree that much of the features, as they have been conceived in the Rome Statute and in the rules, have been, to an extent, copied and pasted. Take, for instance, the Special Court for Sierra Leone, Special Court for Lebanon, or at least been an incredible source of inspiration for other hybrid institutions that have been created after the ICC. So I think that if we look at the concept and the sort of activization, as long as that word exists, activation, of the entire system of victim participation, I think the ICC has had a pioneer role, and a positive one, because again, lots of the features that we've put in action have actually been taken over by others. Now, quickly maybe, in order to sort of put the whole system in the proper confines, To the extent that I know this, because I was not in Rome, so an often heard sentence, I was there, I know it all. No, I wasn't there. I have been to Rome, but as a tourist, many years later. Doesn't count, I fear. What I understand is the rules and the half article that we find in the statute, Article 68, paragraph 3, the only part in the entire statute that speaks about participation of victims in the proceedings, as well as then the relevant rules of procedure and evidence, were a novelty. That's what we all know. We didn't have victim participation before. And I think those that pushed for it were not necessarily in the majority, and the outcome was something that wasn't necessarily reflected in its absolute details, and there wasn't a clear concept as to how this would pan out. So there was a lot of leeway, a lot of uncertainty how this actually works. And discussions in the early years were this beautiful two-sided approach. One, we're saying we want in no instance that the victim participation slows down proceedings or impedes the rights of the defense. Others were saying, we do not want to have victim participation that is purely symbolic and that actually doesn't give anything to victims. So you had these two sides that were fighting against each other, and in the middle you had the ICC trying to make sense of the words that they were reading in the statute and the rules. And the interesting thing is obviously that it all comes down to what you do in the field. So you can talk about the rules as long as you want. It starts with you coming to Bamako, coming to Bunia, coming to whichever city, country it is, where you then realize, okay, now how do I find the victims that fall within the remits of a case? How do I address them? What am I going to ask them? How much information do I have to take from them in order to fulfill the standards of the chamber that this victim can actually participate in the proceedings? Am I stepping on the feet of the office of the prosecutor, who might still be carrying out investigations, who might still actually be speaking to people in the exact same communities that I would be targeting when I want to speak with victims? So there's a lot of questions that you only start asking once you get there, because they're not written either in the statute or in the rules. And this is what I think the court did, or the registry did, in the first years, to actually figure out what are the key do's and don'ts in order to make the system work. That, I think, was really the first 10 years, to really sort of get the system going. And I think if we then look at it from what happened in the second half of these 20-year cycle that we're looking at, we started getting into the fine-tuning. And this is where I had the benefit of coming in, where actually the proper work was already done, and then you can basically get all the credit of the system already existing, and you just do a little bit of fine-tuning and everybody prods your shoulder. Fantastic. So here I am. What we did in order to then really make it even more tangible was to fine-tune how much or how little I need to actually produce from victims in order to enable them to participate in the proceedings. This is as simple as this. If a chamber says, for a victim to participate, I need to have as a minimum the victim participation form, if you have one, plus a passport or an identity document and testimony of one person that what this victim says is true. Now that gets you into real trouble when you're trying to put this in action in the field. We have situations where people do not have identity documents. They may have a tiny little refugee camp card, if anything at all. Go to the refugee camps of the Rohingya in Bangladesh, and you will see people that have nothing. Likewise, find a witness that testifies to the suffering of another person. it creates an incredible burden in terms of how much information you have to produce in order to actually make victims be able to participate. And mind you, we're not talking about 10 individuals, 20 individuals that you have to target. We're talking about hundreds, we're talking about thousands. We had it yesterday. You can scale up the cases in terms of the victim communities affected. Quite topical. Again, Rohingya, 750,000 in one camp. And that's not the diaspora. That's not those that have stayed in Myanmar. So we're looking at even more. Or take the most topical current case that we've already discussed in the Ukraine. But we don't have to go that far. We can also stay in Sudan. We can stay in Central African Republic. We can stay in Uganda, and we get to double-digit thousands. So here is your problem. You want to establish a system whereby you have a maximum of victims participating in an easy manner without that becoming a mere numerical exercise. And here's, I think, also the key. As much as we would be pushing chambers to be lenient in terms of their requirements for victims to be able to participate, at the same time, as a court, we have to be careful that it doesn't become just an exercise of the court being able to say, look, we have 5,000 victims participating in this case, yet many of these don't really know what's happening because they don't have a proper link to the proceedings. So here comes the aspect of legal representation of victims, which is likewise something that is a key factor that needs to be factored into the equation, which again is what makes the system work or fail. At the point where you then have arrived, once I have delivered the victims into the courtroom, they need to be properly represented. Now, we've managed to come around a lot of big challenges that took the wind out of the sails of both the extreme sides of the spectrum, the ones that said victim participation is impeding potentially the rights of the defense in slowing down proceedings, or victim participation is not meaningful. On the one end, we've put in place a number of very simple measures to streamline proceedings. We have a standard application form that we use across all proceedings. If a victim wants to participate, there is a form which it can use in all relevant languages, in all different electronic formats. Granted, in some situation countries, the electronic formats and all this is not really interesting. Again, there was a time when in the Rohingya camps, the internet was shut down. Well, in those cases, everything that's electronic doesn't really make much sense. On top of that, Rohingya is an oral language, so the question then is, what do these individuals do if they cannot read what we're proposing them? So this is, again, where another big factor comes in. You need to actually have the manpower as a court to also put these things in action. So this comes then to the challenge of how many people do we have as a court to do this? And how much are we willing to spend on this? And now when I say we, I'm looking at it from a state's perspective. Because you have to throw some money at this feature of the ICC in order for it to work properly. Now, we have the application form. We have engaged in means to actually also make modern technology work, using iPads, for instance, instead of paper forms. If you're operating in a context where you have armed conflict ongoing, high-risk situation for victims, the last thing you want is a victim going away from his or her interview with a copy of a document back into an area where they may be detected as somebody having something to do with the ICC. That is the risk factor. Nobody cares whether they're a victim or a witness. They're going to be perceived as, you had to do with the ICC, so you are potentially a traitor. That needs to be prevented. But likewise, the person that took the statement needs to be protected. If you run around with a stack of 250 application forms, you are a potential target, and these 250 application forms contain data and details of victims, which we normally hold confidential as the court, But obviously, if you lose them in the field, they can become incredibly dangerous material. So these electronic means obviously give you the power of deleting swaths immediately or having a fast upload capacity through secure channels to court servers. Modern technology, which, however, we have to be mindful, work in some situations, but not in others. And that goes as far as trying to find a one-fits-all solution is difficult, if not impossible, if you look at the broad scale of different situations that the ICC is facing. Another key factor is obviously the whole protection issue. The issue of, first of all, explaining to victims the one key factor, and that is you are part of a protection program, witness protection program, if you are a witness or if you are a victim appearing before court physically. You do not get any protection if you're just a victim participating in proceedings by giving me one of your application forms and then me organizing legal representation for you. And that is a key factor that needs to be understood. These people do not receive any protection whatsoever. And these are the thousands that are participating, not the 50, 100, 150 witnesses. That's a key message to convey, which I think is often also something that is underestimated. That gets me into the whole expectation management narrative, I think, which is also very important. For everything that you do, and that doesn't matter whether you're the ICC, whether you're the Kosovo Specialist Chambers, whether you're whichever hybrid institution you want, and you have to deal with victims, you have to be very careful in what is it that you are communicating, and how much do you have to communicate in terms of active expectation management. Translated into a concrete context. When I go out and I speak to a victim, I need to tell that victim, you can participate under this and this and this circumstance. But, mind you, it may take some time for trial proceedings to start. You may actually no longer be a victim at trial if the pretrial chamber shaves parts of the case. In case of a conviction, you may be entitled to reparations. But if there is no conviction, you may not receive reparations. That's usually the part that people do not hear anymore. And mind you, I'm not speaking then to an English or a French audience. I'm speaking to an audience that usually has an interpreter next to me who then translates into the relevant language. So I can't even control exactly what is being said. So you have that level of complication as well. So you are looking at a lot of complication, yet I think that by and large, where we are today in terms of figures, but also in terms of feedback, the system seems to be functioning very much to the surprise of many. We do have victims participating meaningfully. We do spot checks. We don't do proper monitoring. So this is where I'm totally with you. Monitoring is, more than just spot checks, I think is a key feature that we as the ICC can't deliver right now because we simply don't have the resources, but it is a necessity. And the ICC actually considered that itself in its first and second reports on performance indicators, where it said, we would love to do this, but we can't. So I think that by and large the system works, and what it does not do is slow down proceedings. I have yet to see anybody who gives me any testable example where victim participation would have slowed down proceedings. Proceedings are being slowed down by all kinds of things that are inherent to criminal proceedings. Victim participation is not part of that. So I think by and large we can say we have established a system that works. Can it be improved? Oh yes. But let's not fall for simply saying it needs to become more effective and more efficient, because first of all, let's look at all the challenges and see whether the compromise that we found isn't potentially already on a pretty good way. I'm very happy to engage with everybody because I'm always happy to hear more ideas of how we can further improve. But yeah, just that sort of as a certain, as an attempt to address the area of victims in international proceedings from the ICC perspective. Thank you.
Thank you to our distinguished panelists for these presentations. We actually have almost an hour for discussion, which our chair will facilitate, and we have questions, I understand, from the audience, as well as we have some online. But if you would like perhaps to pose a few questions to the speakers before we would like to start with the audience. Are there any audience questions, or shall I start with what we have online? Okay. Very good. Yes. We have a few.
I will take a little bit more time, actually. My name is Franziska Eckelmanns. I'm the acting executive director of the Trust Fund for Victims. And I'm really grateful that Professor Pham talked about monitoring and evaluation perspective. And I think I would like to just contribute for a few minutes, really from the experience of the cases that we are actually at the moment implementing. Just very quickly, what is the Trust Fund doing? So together with the court, we form the pillar of reparative justice of the Rome Statute system. So that means in the very first place, we are implementing court-ordered reparations. And you have heard from the professor, there are at the moment 5 cases that came to a conviction. There are not yet 5 reparation orders. There are actually only 3 in force as we speak. First of all, there is the Katanga case. Katanga was convicted for very, I'm not going into details. There are 297 victims of the attack on Bogoro that were found eligible by the chamber. So there is one group of 297 victims. They receive reparations since 2017. First, they got an individual compensation, $250, and since then they receive collective reparations. And the Trust Fund itself actually conducts this reparation implementation. So we are going with the victims to the market and buy what they need for their income-generating activities. We are giving the money to the schools where their children receive education. And we are also looking into how they are building their houses at the moment. So it's a very, with our people on the ground in Bunia, we are monitoring this program, but we are also implementing this program. And I think one of the features, these victims are closely, I would say, connected to the legal representatives that run the proceedings with them, and they know that this 1 million award against Mr. Katanga, in which the Trust Fund stepped in with its own resources, is really for them. So they got these 1 million. It has been distributed through the award for them. And they are very aware of that because they were included in actually designing this entire reparation award. But nevertheless, they had these questions of, the chamber said the liability is 3 million, then they reduced it to 1 million in the judgment because it was just contributing to the crimes. He was not the main perpetrator. I said, what about the other 2 million? So where are they? Why don't we get them? So that's typical victim, what they come up with in the field when they look at our proceedings. I jump now to Lubanga. In Lubanga, we are now implementing reparations for, I think in total there will be 2,400 beneficiaries. And they are receiving a very full program, actually, the fullest program we have been providing. We are running that for 2 million a year, where we are serving about 1,000 victims a year. So there is a proper investment per person that you can see, basically. Nevertheless, they say 10 million was the reparation award. Where is the money? Why don't I get this money? Why don't I see it? You know, so there is this expectation that they connect to the reparation award, but then they have talked to their lawyers over all these years. They said, but I wanted a house. I told this to my lawyer. Why don't I get it? You know, the questions that they received over time, this built their expectations. They thought, they were told, they were promised that they get what they were asking for. So that's a huge issue, these expectations that we are dealing with. In this specific case, because it's in the middle of a conflict. It's in confidential, it's still confidential proceedings because these are former child soldiers in an ongoing conflict. Yeah, so it's a difficult situation we are dealing with. So it's all also about resilience in the end. Then we are dealing with a completely different situation in Timbuktu, and we will speak about that in the next session. But there we have overcome so many challenges to actually provide individual reparations to the persons who are family of the saints in the mausoleums that were destroyed. And Judge Pangalangan is here. He was the presiding judge of the chamber issuing the reparations order. And we were able to overcome the challenge of only giving reparations to the men, because only the men saw themselves as the, you know, as the descendants of the saints, by saying, no, the chamber had said actually, you know, the woman should be included. So we have given the reparations also to the women. We know them personally. There are 980 victims at the moment that received reparations in a situation where we cannot go to Timbuktu, where we had to have intermediaries. So many challenges overcome. But that at this very moment, the biggest is they keep coming, yeah? And the chamber wants to say, there's a timeline, we need to end it. But they keep coming because we are active. We are still providing collective reparations. So they address us. So there are these 3 cases at the very moment. We also have started initial reparations in the Antaganda case. There the problem is victims in a conflict situation, where are they? We don't find them. They are in the books, but we cannot get to them. So it's one of the biggest challenges in that very case. Finally, I mean, we see these cases, but we have a broader mandate as well. And you have heard that yesterday as well from the president of the court. We have given a form of reparation in the form of physical, psychological, and rehabilitation and material support to many victims in situation countries, especially in Uganda. And we just came back from a mission to Uganda with quite a number of states parties. And the chief also talked about it. And I think when we go there, what I would like to just get back to the panel here as well, 16 years after the conflict, there is peace. That was what Professor Phuong said. Peace, basic needs, recognition, redress, as well as truth. So there is peace. The basic needs are quite well provided in northern Uganda. It's now all about still addressing the harm that they are suffering. The recognition and addressing the harm, that is what they are all about. And the call to all of us was, please, not just me, but also my neighbor and all the other people, they need to get reparations. And then truth. There was an amnesty, and that's very questioned these days in Uganda. At the time, it was the right thing. Now, that's questioned. You know, truth is the last. Once you are better, then it comes to that. So just wanted to also mirror that. Finally, I'm not there this afternoon for the 5, 10, and 15 years, so I'm just bringing that here. it will be very essential, I think, that the court together, with VPRS, with public information, that we have these engagement strategies in every situation country. Every situation country is different. The victims' needs are different at the time we enter compared to at the time when we later on get the reparations. But to have a common approach to what we can do as a court in these countries through evaluations, through basic, you're right, there are only 2 evaluators, one within the trust fund and one for the court internally, not for external evaluations. That we look into this situation and make some assessments that are essential for how we work. And then evaluate over time. I would think that would be extremely valuable. And also managing victims' expectations and making it possible they get a form of what we call transformative reparations in the end. Thank you.
Thank you, Francisca. Prosecutor Ocampo, would you like to take the floor next? I think you were next to the microphone, and then Judge Hofmansky, and then Bridget.
I think it's very interesting to understand the internal functioning. Thank you for that information and your information. I'd like to add to that the vision of the prosecutor office, or at least in my time, because there are 2 problems. One is the prosecutor has to select cases in the situation. If not, you cannot present all the criminality. And that creates conflict. Philipp explained some of them. In particular, in the first case, we did a case at the end, we ended with a child soldier case. So the victims were the Hema community, who were also the perpetrators. So then the other communities feel, what's happened with this? They kill us, and they are now the victims. Because the selection was child soldiers. So the whole Hema community was the victim. So that I think that presents the conflict between the judicial logic that we need to prove a simple case before the court, before the judges, and the reparation for the victim, which is a different problem. And I think that should be very clearly. That was my first point. The selection of cases required by a good prosecution case is affecting or has to be taken into consideration in the criteria to select the people who could be in the court or compensated. That's the first question. The second question I like to talk, because judges are here. In my time, we had a big fight with the judges, some of the judges. We had Philipp Jordan, Judge Jordan in those days. He wanted to impose the civil law system where the judges investigate the cases. And so they were expanding the victim participation, allowing the judges to drive the investigation. And that was really affecting the proceedings, and the appeal chamber transformed that. And I just put this as a reminder because I don't know what will happen in the future. The biggest difficulty in terms of proceedings is judges using the victim participation as a cue to expand their role in the investigation. And the third point I want to make is connected with Phuong say, the evaluation system. The problem is, if the evaluation system belongs to the ICC, the judges will define the evaluation. And what we are watching here is we need a much broader view. And that's why maybe the best idea, and here maybe Botswana can lead, is to organize like a group like a Phuong group to do the evaluation for the ICC. And also for themselves, because Phuong is sitting in a gold mine. She has information for 16 communities around the world, and for the last 15 years. So we have to understand, she knows everything. She has information in her databases. So my ambassador, I like to support you if you lead an effort to organize, to have an agreement that we sponsor some external evaluation for SEC, not inside the budget, outside the budget, an external view, someone who knows the problem, and then the evaluation should be much more comprehensive, not just what happened in court, what happened with the people. So that's my 3 comments. Thank you so much.
Judge Hofmansky?
Thank you very much. I will keep my comments, my question short. Firstly, I will ask a question to Philipp Ambach. You said, probably rightly, that it's not possible just to standardize the requirement need to be met by victims to participate in the proceedings, because it needs to be determined on a case-by-case basis. And I hear maybe a little bit between the line of your presentation that there is a small allegation against judges that they are not properly informed about these issues. And the question is, what could be done to improve the situation? Maybe the idea would be just to make the research, to report to the judges before they make a decision about the victim participation. Maybe it would be the idea just to bring judges on the ground also, and then just to show the situation in place where the crimes were committed. This is the one point. The second point I would like to raise is about the influence of the victim participation on the speed of the proceedings. I fully agree with you that it is our experience that the participation of the victims does not delay the proceedings, but I think that there is a price we have to pay for it. And the price is that the reparation proceedings start after the convictions. And the result is obviously extremely long, and the victims wait for the reparation for many, many years. Sometimes we have the case that many of victims died in the meantime. It makes many, many years, 10, 15, 16, 20 years. It's too long. They wait for the reparation for the atrocity crimes they experience. Need to be faster. What can be done? What can be done? Do you think it will be possible to issue the reparation order on the time of conviction, maybe on the time of sentencing at the same time? But if it would be the case, how we can prepare the decision during the criminal proceedings? I note it's complicated, but maybe there are some ideas of the panelists just to help us. Thank you.
Thank you very much. Thank you, Mr. President, for these questions. Two very, if you want, key topics in terms of the entire discussion on victim participation. Standardization on the one hand, rendering more efficient on the other. On the standardization, please don't misunderstand me. I think that we managed to standardize quite a lot. Again, the application form, the general way how we proceed, and in particular, we now have a standardized approach of chambers to the entire admission procedure of victim participation, which is since February of this year part of the chamber's practice manual in some detail, which is really, I think, one of the main achievements of the last years. If you read it, there are no open questions anymore as to how the procedure goes. That's something that I think is a great step forward. As pertains to the specifics are what happens on the ground. And the way that we currently cater for it is that we report, when I say we, the registry reports to chambers, sometimes even proprio motu, that is without having been specifically requested to do so, and explains to the relevant chamber what are the specific challenges that we are seeing. A tangible example being right now the Abdurrahman case, where I think there is a very dynamic situation which we're trying to portray to the chamber at every single step, so that the chamber is aware and thereby can understand in which specific setting the standardized approach attaches and the results that come out, which may obviously be different across cases, right? So I think that by and large, that is a system that is well oiled and in operation. But obviously, and I'd be very interested to hear whether there are ideas of how to standardize this further. We have some chambers that say, report to me every 3 months, which, however, I would be doing anyways because I have an interest in the chamber understanding what is the situation that I encounter on the ground. the price we have to pay, Mr. President, in terms of the length when it comes to reparations, I think here indeed we're looking at something that was rather unfortunate in the first cases of the ICC, the simple duration for many different reasons, why things became very drawn out, partly also because the judges had to test the system, and all players had to test the system first. And I just want to raise awareness of two very interesting decisions that have been rendered in the very recent past, one by the trial chamber in the Said case at the very beginning, and another just very recently by the Abd al-Rahman trial chamber, in which it said, registry, even after we have closed the window for victims to come forward and participate in the proceedings, continue to collect information on reparations, because we will ask you at the end of the trial to give us the fullest picture you may have collected up until then of potential beneficiaries, the universe of potential beneficiaries, be that victims participating in the proceedings, be that victims that are still outside. Now that, to me, if the job is well done, could lead to exactly what you were thinking of, and that is a reparations order that would be issued very early in the reparations proceedings, shortly after the sentencing, if there is obviously conviction. And that could have a major catalyzing effect for speeding up proceedings quite considerably, because in that case, the trust fund could step in at a very early stage, would get a full package of information with which the trust fund could then immediately move over to implementation. It still needs to be done. So this is homework for us right now, and I hope that we're going to satisfy you.
Yes, let me just say something very clear about the question of, first, the question of the reparations. The question of reparations should never be anchored on the question of guilt or innocence or the outcome of the case. We have again to rethink exactly the procedure we put in place and the mechanism. We already have the trust fund for victims, but that is not the end of the story. We have to look again at the whole notion of complementarity. And I say this because the state party, the state is always invited to make submissions. And they make submissions as if they are throwing the responsibility back to the ICC. No, they have a state responsibility to start a reparation program, to have that discussion with the ICC, irrespective of the outcome of the conflict. And they have a contribution to make. In a situation where they've granted amnesty, that puts many people will not come, and where the victims themselves and the witnesses will not have other access to justice. That should not close the door to state responsibility. And therefore, the notion of complementarity, I'm a bit concerned that I look at the decision of the ICC, and they have not yet had a full debate, a full reasoning on the extent of complementarity. They limited it to whether the state's size, primacy on starting the cases, or it's to come to the ICC. No, it's to go further than that. It's to go further about the fate of the people in this young country. And let me say one thing. Another aspect is that one of the key elements of a criminal trial is to keep a historical record. Many years after these cases, like we sit here today, those of us who were not born 70 years ago, but because of the historical record in the cases that took place in Nuremberg, we are able to be inspired. The world is aware that it happened. It has that deterrent effect. So the ICC, in taking the historical record, and I think in the case which I am there, without going into the merits again, as I said, the case went, we try to preserve the historical record. And this is one reason why the outcome of the cases in the court, especially ICC, they come out the way people think. What was promised by the prosecution and what those witnesses say in the court. They know the perpetrator, they know the crimes. And it's not in every case because they're a prosecution witness that they must develop the theory. They come before the court the way the case turns out in the courtroom. So when you keep the historical record, it helps in the reparations because that may be the only opportunity for those victims to tell their story to the world. And merely having the opportunity to keep the historical record, it brings about the healing. It's part of the reparations. I am amazed, being an African and being a traditional ruler, to hear reparations reduced to money only. It's not part of our culture, many cultures in Africa. Well, what the people simply want, even the victim and others, is justice. That the person who killed my relatives, the person who raped my daughter, the person who raped me, I was able to tell the story to the world and put it in that record. If this generation does not want to take care, some other people will look at it, or my grandchildren will come. So we should look at different forms of reparations and make sure we take the victim's perspective. I talk about the matter of put. I do not know whether the court will adopt it or not, but merely telling that story and keeping that record, that culture is known, that alternative method is known for the victims when they come back. You saw the clamor by their chiefs, the Juakas and others, to come to the court and tell the story, and they were able, the people were clapping. So we should rethink state responsibility in the context of complementarity. In the case of selection of cases, thank you, sir, it is extremely important. They live in the community in which, because of amnesty and other recent pressures, only one side is brought to trial. And I can tell you, these victims resent that. They resent that because they know justice is not done. So you end up trying to solve a problem by creating more. The others go back and say, oh, yes. So what you need to do is to take over power, use force, and if you take over power, you isolate yourself from persecution. Otherwise, the court is victim's justice, that perception. No. The only way you can help them to mitigate that problem is the historical record. A historical record is linked to reparations because you must know other forms of reparations will be acceptable to them. Some just want to rebuild their lives, reconcile, accept back the victims to the community by going through those processes, find out, talk to their leaders, and see how you can take that into consideration. The people will be very, very happy about that. That is my humble contribution.
Yeah, and thank you so much. And I'm so happy that Philip was able to come here. I think his and Francisco's interventions was much needed. I think we always need to contextualize what we're seeing and some of the reason I think, and some of this process, I actually also think this needs to be documented. So I think it's a great interventions. You know, I think going back, a couple of things, I think just to touch back on just what you said, I think historical records is really important. And you know, when we do the surveys that we do, we would design the questionnaires. And in the US, right, when you design any surveys, you want it to be 5 minutes, 15 minutes, right? Because no one had the attention span. And look at this Slido, one question, right? But in some of these situations, we would design and we were careful to say, look, we won't want to take more than 30 or 40 minutes of their time. But actually, sometimes our survey lasts 2 to 3 hours. And then even when we finish, sometimes they come and find our surveyor and want to talk more. They really want to tell their story. And, you know, everyone that we speak to always said, you know, we want people to understand what happened to us and our family. And I think this is a really important aspect. And I think this is why also engagement, like you mentioned, with the victims and the family and the affected community is so important, because it's their opportunity to be recognized and acknowledged, and to just for us, the international community, to understand what happened to them. So I think that's an important point to mention. I think the second part, and I want to mention about the reparations. I think I do, based on my understanding, there are reparations that are providing, or what they call right now, I think, assistant programs that is not linked to the convictions, right? And I think right now, based on what I understand, there are programs that are ongoing in 4 countries. I think in Central African Republic, Cote d'Ivoire, DRC, and Uganda. And I think, you know, I think Francisco mentions about thousands or a couple hundred people receiving the reparations on the order. But on these programs, I think in 2021 alone, more than 18,000 were beneficiary for that. So I think there's potential there for having these kind of restorative assistance to be expanded some ways. And maybe the court doesn't have to take its sole responsibility. They could partner with humanitarian organizations on the ground, development actors. I think somebody mentions about, allocating some of the rehabilitation budgets from the World Banks and others to provide some of these assistance and referrals to those. So I think there might be ways to expand. And when we, like in the Uganda situations, when we did the interviews, over 90% of the people in northern Uganda were displaced because of the conflict. That's lots of victims, and many of them witnessed lost children, but was abducted. So there's a lot of victims there, and I think some of these larger programs could help meet those needs. I think the last things is, we're hearing a lot of context and record, and I think I can't stress enough, and I don't think it has to be us only. I think there's a lot of other people from different disciplines that could take different perspective and view of evaluating the court processes and outcomes, right? You can study the Rome Statutes, applications, you can look at the institution itself, and you can look at some of the activities. So there's multi-levels of analysis, and I think the task is large, and so this is why I emphasize the need for partnerships with many people in different disciplines using different approach to understand the court. I think it is an innovation, as I mentioned, and it is a system-wide change that we need, and I think we need to systematize or look at this, both the Rome Statute and the court from various perspectives and using different methodologies. Thank you.
Thank you. Bridget, did you want to ask a question now? Thank you.
Thanks. Well, thank you to the panel. This was, as expected, it was a wonderful, wonderful session. I just have a couple of reflections. One is affirming, Philip, your comments about how difficult it is on the ground and in the conflict situations in terms of victims' participation. Many years ago, when we used to do the annual gender report card on the ICC, we used to analyse in great detail every aspect of the court, but including victims' participation. And one of the things we noticed was that there wasn't always an inclusive profile around who was participating and who was being reached by the court's participation program. And even in cases where the charges reflected sexual and gender-based crimes, for example, and specifically of women and girls, we weren't seeing that profile reflected in victims who had been reached nor applied to or were seeking to participate in the proceedings, that overwhelmingly, regardless of the case, and I think there was probably one case that was the exception, I don't remember what it was now, but otherwise predominantly the victims participating were men, regardless of the charges and the profile of the case. But beyond gender, of course, it's also by ethnicity or era in which the crimes and acts and harms occurred, and also by age. There's a number of different profiles and identities that need to be taken into consideration in analysing and assessing whether you're capturing all of the victims, all of the people victimised by certain types of crimes in a given situation, which I know your team is conscious of. I really, Chief, support your wonderful comments around the role of the state with respect to reparations. And this was something we noticed in our work in northern Uganda and eastern Congo. And in particular, let's say in the Lubanga case and reparations, the need and the desire by the victimised communities to have a sense that they would be receiving reparations from someone that they considered to be responsible for the harm that they experienced and for the crimes that occurred. And in the case of the ICC, that hasn't been, to date, the direct perpetrator or the convicted person, but nevertheless, victims perceive there to be a legitimate role for the state in contributing to reparations, whether that's through symbolic reparations, whether it's through an apology for failure to protect and prevent, but some engagement of the state. And I think Phuong, it goes to your observation in relation to the Colombia situation, I believe, where the repair element was perceived from the victim with the state with respect to reparations, but not horizontally. And it makes me wonder, and I'd love to hear your comments on this, who victims before the ICC feel repaired with? With whom do they feel a sense of restoration and repair and reconciliation if the reparations are not coming from the state or the perpetrator, are coming from a court and an external independent third party? Where is that quality of reconciliation and healing and restoration and repair? Amidst all of the challenging operational aspects, there is a purpose and a value and a mandate embedded in this that I think we don't want to lose in our inevitable pragmatism.
Judge Eba Usuji next, and you will be after, if that's okay.
Thank you. Thank you very much. I want to join on to that, what has been said so far. The idea of delinking reparation from conviction cannot be stressed enough. The victims, and this thing came up in the Ruto case, and there was a separate opinion that I wrote in there where I said, look, reparation doesn't need to be linked to the outcome of a criminal trial, because you're sitting in a case and you see clear victims of the armed conflict or whatever it was that happened in that situation. It's a separate question from who is responsible for what happened to victims, which is what proved beyond reasonable doubt is about in a criminal case. And how the victims cannot be burdened with the outcome of that process in terms of proof beyond reasonable doubt, because they are not controlling the prosecution or the judgment, but they know something happened to them and nobody can deny that. So it becomes unfair to them to say, well, you only get reparation if an accused person is convicted. And that can lead to a lot of dissatisfaction. And in other places, Canada, for example, and New Zealand, I believe that's where this thing started, there's something called criminal injuries compensation that is given to victims of criminal injuries regardless of the outcome of a criminal trial. I think we need to emphasize that, and what Dr. Pham said there about exploring links with UNDP or World Bank to see how they can assist in that program is critically important. The question that Bridget raised there about who do they feel repaired with, it's a very important question. Clearly, the state that failed to protect them, states have that responsibility to protect. And if they fail in that, there's a question of reparation on their part, again, regardless of who is convicted in a criminal trial. If the state is unable to do that because of lack of means, there's nothing wrong with international community also chipping in as part of the recognition of what happened to the victims. So all these, it has to be a multifaceted approach to trying to make victims whole, trying to repair them to the extent possible. And that's going to ease the pain that they suffered, regardless of where the source of reparation comes. Thank you.
Should we take a couple more questions and then you can respond, or? Yes, okay. Please identify yourself and ask your question. Thank you.
Hi, good morning. My name is Ana Milena Coral Diaz. I'm from Colombia, currently working at the BPR section in the ICC. Also have been working with the United Nations regarding gender affairs, and have been working also with a special jurisdiction for peace in Colombia. So my question is, because I have been working with victims, women and girls in Colombia, I have this experience with real victims. And I have a question regarding how to implement reparations and the reach out, because also the reach out of victims is important. How can we implement that from the perspective of gender? And if we have a perspective of gender based also not only a universalistic perspective, but also a local perspective. How can we make that women and girls from local communities are heard? That's my question, and I would like to hear your insights. Thank you.
Yes.
Hello, my name is Karen. I'm from Roskilde University. Thank you very much for this panel.
Bring the microphone down a little.
Bring it? Okay, there we go. I think my question is mainly directed at Dr. Pham. I'm quite interested in the fact that victims are expressing that what they really want is a recognition of their harm through the ability to participate. How does it affect victim communities? I'm wondering if your research tells you anything about that, that some victims are recognized, as the legalized victims within the parameters of the court, with the narrowing scope sometimes as well, even of victimhood during the procedures as they progress. How does that affect the victim communities at large? And then I think also for Philipp, a small thing, because you mentioned that victim participation has not slowed down procedures, and I would tend to agree with you, but I also think that has come at a cost. In some cases, victims had submitted applications on time, but due to a backlog at the registry, these were never transmitted to the chambers, and that left these victims in a legal void where no decision was made on their status, effectively barring them from participation and accessing their rights. I agree with you that the implementation of the ABC approach has very much streamlined this procedure, but I still think there's a risk of this happening in future, depending on the number of applicants you receive. So a bit of a, what are you doing to ensure that that doesn't happen in future? Right, thank you.
Wow. The president of the ASP said yesterday that she hoped that people would forget about questions that were being asked. I think that hope that she hosted, I might also host that in vain. So maybe just one reaction to your comment, Bridget. I fully agree with you. The granularity of victims or victim communities and how much we can drill down in a way that we give a full picture of the differences of harm, the differences of gender-specific harm, the differences of age, the differences of ethnicity, to give the full universe of victimization, of victimhood, of harm, is extremely difficult to carry out. And obviously, the more time you have, the better the picture gets. So usually, if you see really also an increase in quality in the registry's reporting, from the first report at pre-trial, just before the confirmation of charges, as it then moves on to trial. And luckily, and here's one big benefit from chambers having been very attentive to the victim mandate, chambers have just now ruled in the Chambers Practice Manual that we registry have more time to actually bring victim participations in participation forms into the proceedings, which is the entirety of the prosecution case. Obviously, we would have loved the defense case as well, but we failed on that advocacy. Music for the future. So I'm with you, and we're working on this. We're trying our best. And actually, I have to say, I quite enjoyed the fact that you were asking these questions, because what does this do? It is the monitoring that we're looking for. It's exactly that. Who is the best monitor for the activities of the court? Well, the NGO community, be that the international NGOs or local representative bodies of victim communities, because they know arguably best. Then maybe a quick response to what former President Ibu Suji said in terms of the reparative effect that should go to all victims. I think that that's spot on, in that the Rome Statute system provides for victim to be any person that has suffered harm of a crime in the jurisdiction of the court. It doesn't speak of a crime that is tried in a case. So from that perspective, Rule 85 is open to any victim of the situation. I would simply, maybe in order to circumvent any legal discussions regarding Article 75, I would say all victims are entitled to a reparative effect, to some reparative action, and would leave the term reparations for what is the court-ordered reparation after a conviction. And I'm pretty sure that the trust fund will have a lot more to say authoritatively on how the two mandates of the trust fund can actually come into play in order to cater for a seamless and inclusive model that would cater for also those victims that fall at any given point outside of the confines of a case. Quick one on Karen, in terms of the system as it is currently applied with chambers, how victims can apply and be admitted to participate in the proceedings. Right now we have a streamlined system by which we actually do not disclose the entirety of victim forms to all parties. So we only disclose those to all parties that we consider raise doubts as to whether they fall within the confines of the case, so that there is a focused discussion in chambers as to which victim stories or general themes fall within or outside of the remit of the case. That helps the chamber to define actually what the charges are, together with the parties, which village is included, which village is excluded, which crime is included, which crime or which act is included or excluded to fall within the crimes. You're raising a point that was, I think, very pertinent, where the chambers had decided that the time of the registry to submit victim applications was very short. And that was the period of pre-trial and trial preparation. It's a year. Take circumstances as in many of the situation countries with active conflict, a year is nothing. You don't get, in some cases, your foot on the ground, quite literally, in a year, simply because you can't travel to these countries. Now we have arguably a year more because we have the prosecution case. So I don't think that we will run into that same problem that we have experienced in the past, that a backlog of victim applications wanting to participate, having submitted their forms on time, cannot be processed for the lack of registry resources. So I don't think that this is a risk, but again, my advocacy would be, give us even more time, dear chambers, but I understand the reasons that have been discussed by the judges in their discussions, which are just as valid reasons to limit the system in order to make it work. I had to say that, otherwise I get fired. Thank you.
I totally agree with Honorable Judge Oboe-Soji, the points he has made, because if we premise, if guilt becomes a predicate for being entitled to reparations, it does one disservice to international justice. Because acquittals or convictions in the ICC, the ability for people to come there and actually get justice, and they're acquitted sometimes, is what enhances the credibility of the court. The court needs this credibility to have the legitimacy that the world requires, and therefore also celebrate. The ICC should celebrate if there's a conviction, final conviction, or when there's an acquittal. It should not be a predicate for reparations. Now, let's come to it. The ICC is now having the responsibility for a very important issue that has existed before the civilized world for so long, but the ICC now is being called upon to bring a solution. Take note, and I agree with my friend Professor Maxwell, 1945, the United Nations did not contemplate the existence or the rise of non-state actors. Today we have terrorist organizations, we have multinationals, they have major impact far beyond state parties in order to commit crimes in different places. The victims of these crimes is only the ICC now that has come to have the responsibility of making decisions involving these victims on behalf of the international community, not just the state parties. It affects everyone. And therefore, in order not to compromise its independence of making decisions on acquittal or conviction based on the evidence before them, they must think outside the reparations regime that exists. The case of the Banga will never be resolved. 10, 20 years today, the victim will still be certified, and it does one disservice. It destroys the cultural and social values of the people that they can get money. Whereas in the same community, for the same crimes, they just need some traditional rituals only, which are acceptable to regain their liberties. Why should they depart? Why should the ICC create a different value system for the people to have full reparation to regain their liberty and their dignity? So I agree with Judge Obusuji that the state parties in the situation countries and even international community must take part of the responsibility if they want that this burden they put before the ICC to continue to save humanity right into the future. And I say this because those of us who go to the field for 23 years of uninterrupted representation in international courts, either in Rwanda, Sierra Leone, I've been to the battlefields, I know to the forests in Congo and other places, the affected communities. I've been there and I know what reparations, total reparation in their own context. They were not waiting for ICC to repair their life, to have some form of reparations. And even irrespective of the judgment of ICC, if the convict goes back to the community, he still has to go through to be accepted. What will the people accept will be those rituals. But the state responsibility must come in. They should not make representation and say, let that convict pay this. They're indigent, and somebody, the ICC does not, it is not a business enterprise that they will say, we'll gain profit and give this. The trust fund of victim is there in an attempt to represent the international community in a way, but the state must. Therefore, I totally endorse the position of Honorable Judge Obuosoji.
If I could flag a question that came online that I think is particularly relevant based on this discussion, and it has come up in a few forums in the last hour. Someone had posed the question to Dr. Pham, what would you suggest, how do you bring your scientific conclusions to a legal community? How do you bridge the sort of gap from producing the research and the results to trying to see it recognized or understood or implemented in some way by a very different professional community that bridge may not yet exist. And I think even in fact of the volume that the Academy did on deterrence, and I think we might have had some discussion about maybe we should organize meetings at the court and explain our findings and see if these are relevant. And this would be actually a very obvious thing to do from an NGO civil society perspective. I've written a report, now I will go share it. I will go have a discussion about it and see what kind of impact it can have. Whereas in the academic community, it's published, it's out there, and you move on to the next urgent research or task. And perhaps we do need to explore how to build those active bridges that even in these days you can have a Zoom meeting or a Zoom call and say, hey, I've got these results, you should have a look at them, and find ways to more actively engage each other, because this is really essential work. And I know, like from Philipp's perspective, having that exchange from the practitioner's perspective, having that exchange is vital. So I think, that's what I picked up from the room. Was there another, Francisca, did you have a comment or a question before we have time for a few more?
Just comment on some of the issues that were raised. I think what Brigitte brought up as a point is something we are now addressing with evaluations, of course. We want to see with neutral, external, independent evaluators what is actually the effect on the victims. Are they connecting what they receive as reparations from the court, from the trust fund, with the accused, with the convicted person. And I think the outcome will be very clearly that this is the case, as we have now built the entire structure. The victims of Katanga, the victims of Lubanga, they know this is about these convicted persons. So I think that will be the outcome, but we are measuring it. Then there was the issue of the state's role, and I think the case of Al-Mahdi, where the chamber ordered symbolic reparations, €1 symbolic euro to be given to to Mali, the population of Mali, and the international community. And that was a ceremony that was held 1.5 years ago, and we got the government on board. So the government of Mali was there leading this entire ceremony, then building on it with follow-ups, with a museum. It's been clear to the community of Timbuktu and the victims of Timbuktu that this is a symbolic act by the government of Mali and the entire international community, recognizing also the harm that they have suffered. So I think that's a huge achievement. We are now closing the Katanga case very soon, and it will be essential to include the government, as it is to have the judges there, because they know this comes from the court, these reparations that they received. I think that's essential. Final point. Penultimate point. Basically, Philipp called it a seamless system that we can put in place. We have very little means as a trust fund for victims. We have 2.73 million a year at the moment and huge reparation orders that we really want to complement to the degree possible. So of course, we are raising visibility, as you can see here. We are working on that very hard to get more funding. But indeed, it's quite an issue that there are all these victims addressed by VPRS at the early stages. That was a question raised here. That will never, appear have any after effect. So is it that the trust fund should step in there? That's a reasonable proposition, of course, but then for the trust fund to be then on the ground is what we experience. It's so essential to involve the communities, to involve the victims on the ground. And they don't look at, is that person participating? When they get involved, they say, who is in our community the person with the most urgent needs? How do we proceed best, given there is a limited amount of money? So it's a very different kind of consideration that is happening than to say, yeah, of course, also the participating victims will mostly be victims of the most serious crimes, or they should receive reparations. What kind of justice would we then promote if we were just simply to do that? But we need to find the middle way. So that's a huge challenge. And I think that's something that went to what we need to work on in the next years. Finally, I think the president of the court has raised a key question, is what about this reparation order? When should it be issued? What should it contain? And I'm not giving an answer to that, and I think it's something the court is really struggling with from very many perspectives. But what would it be if there wouldn't be a trust fund and only the person, the indigent person? What would be the reparation order? And what is it that changes because there is a trust fund that is stepping in with its own resources into this entire process, which is a huge novelty and a fantastic creation of the Rome Statute. But yeah, how can we then address the situation that there is limited funds on the one hand, and the chambers, and I think the international systems as well, will to actually find exactly the amount of liability. And that's, I think, probably the key term. It's all turning about this amount of liability. And we are, on the other hand, stepping in with the trust fund funded by states internationally. We are much more on the side that we want to address in a transformative way and perhaps not entirely comprehensively this harm. And that is, perhaps we find a good solution somewhere in the middle there that will make the reparation orders easier. Perhaps we don't need to talk about the amount of liability, but the amount of the reparation order in this specific case. And what is just here to make a more symbolic on rehabilitation-based award. That's perhaps a way of thinking about it. But we are not yet there. It's a huge challenge for the court. And I think we will go together that road, all of us. Thank you.
One final brief comment, and then we will close.
Thank you. So, acknowledging that there are different types of justice required to provide a full remedy, the transitional justice field has identified 5 central pillars to help restore victims' dignity and redress the harm suffered. There's retribution, reparations, institutional reform, truth commissions, and memorialization. And I'm curious, how has and how could the ICC contribute to the pillars of transitional justice beyond retribution? Because at least in the public perception, I think one view of the court's efforts is that it focuses almost exclusively on the first pillar of retribution, though they touch on the second through the Victim Trust Fund and a few other ways. Yet due to the permanence of the ICC, its expertise, its legitimacy, its access, and resources, I think the ICC has the ability to address other TJ pillars that are inherently more victim-centered than retribution, perhaps through adjustments to its regular course of duties. And in recognizing that possibility, I want to ask you all, experts, can and should the ICC develop a more victim-centered approach through the amendments to court procedures, victim intake forms, and accessibility of court materials? Are you already doing that? And can you facilitate victim-centered approaches externally within the other pillars of TJ, happening complementarily in national context, et cetera? What are your ideas on that, or what is already happening?
Yeah, I think that opens a whole nother discussion that we probably don't have time for. But if each of you would like to offer a concluding remark, then I will close the panel. Thank you.
I was about to say the same thing. No, very briefly, I think that that's a very good but also a very complicated question, and I still need to understand exactly what the other pillars were because I didn't pick them up properly. But what I did hear was that you had a question as to how inclusive, in terms of the victim-centered approach, we are in terms of, in particular, the materials that we operate with, and I'm very happy to discuss that with you bilaterally because I think that's going to be very technical, and I know that we stand between you and food. So yeah, thank you.
Just to touch on a few points, Bridget, I appreciate your questions, and I think one of the things is we don't have yet data on whether does it counts who gives who's the provider of the reparations are or originator. But we did find in Colombia, because when we did our studies, we did interviews with the general populations, because at that time you could still register to receive reparation. Then we did random samples of those who register to receive reparations but have not received reparations. And then we did a set of survey of people who actually receive reparations. And what we found was there was no difference between those who register and those who actually receive reparations on how they felt. So there's some sort of things about just being actually the opportunity to receive reparation had some sort of effect. And I think, we've been reflecting on it, and I did some analysis on what are, because I think on how we don't understand yet the mechanism why reparation has those potentially these positive effects. And the thing about it is, in conflict situations, one of the things that is lost, besides loss of properties, is people trust in institution. And what we found out in some of the data is that there was a strong connections between people if they felt that the state care about them, that it has a positive effects on how they felt about the state. So if they genuinely felt that the state care about them, I think that's the mechanism, and I think that trust building, these exercise that we're undertaking is an important thing to consider. So anyway, I'll leave it there with that. Thank you.
I do not really have much to say after listening to the distinguished professor. Maybe you might permit me first and foremost again, once more, to renew my apology. I'm not used to coming late to court before distinguished judges and everyone. It is just one of those unfortunate events, but I did a lot of running. But let me just say something. As the guarantors of the peace and security architecture that they were put in place in 1945, are on a race to deconstruct it and render the people they were supposed to protect victims, all of us victims. The hope of the world, the eyes of the world are on the ICC, because so far there's no alternative, the ICC. And therefore the promote victims is very, very, very central to the mandate. And this discussion should continue, should take it serious. Our children are traumatized just watching on the television, although not on the battlefield. How they use unconventional means, bombs here and there, and the conscience of the world being violated. So the ICC, you have a mission. I don't care about the question of state parties, because the quality of justice you give and how you handle this matter, the legitimacy of the court will affect the entire world. 70 years ago, today we can cite George Jackson and the living legend, George Ferenc, and others. We're left with that. But it was a case of limited number of people. I don't know whether 13 or what. So the ICC, this issue about the victims, of course, all of us are victims. I'm talking as a victim because my own home is at war. And my own palace is occupied by forces. We cannot go there now. We're all victims. Therefore, the mandate is extremely important. We must think beyond the mechanism they put in place for the reparation of victims. We must go further. The international community must come to our support because it has no other alternative apart from the ICC. Thanks.
Thank you. That was a perfect note to end on. And on that note, let's all join in thanking the ambassador who has bravely stood in for Betty Murungi. Of course, please.
Well, thank you very much. I just thought I'd take a few minutes because there were a couple of issues that were raised that did not get the attention. But first of all, to thank all the panelists. I've learned a lot sitting in this panel. Very, good combination of the field research from Dr. Pham here, the academic analysis of the type she does, the court practice from Chief Charles, sorry. I just wanted to wake you up a little bit, Some of the chiefs in Africa were really kings in the past, so I think I should restore his title. And the contribution, of course, from Philipp over here, my fellow substitute, who was called at short notice to come in. I think he did a fantastic job to tell us about how things really work in the ICC, how they are working fine, but that there's room for improvement. So I think that was really a very good example of how this forum brings together these different players, and how we should keep going with this going forward. I think the rich discussions also demonstrate what we discussed yesterday. What are the major achievements of the ICC? I think one of them is exactly this area of victim participation, thinking about justice beyond the court, beyond the sentence and beyond retribution or whatever else you want to say is the purpose of criminal proceedings. So I also wanted to say, Bridget, that I heard you, and I know that we did not respond to your question about inclusion. It was more of a comment, but I wanted to underline, I think I'd be failing in my duty if I did not say that gender considerations are critically important, as is age and ethnicity, as far as the selection of who's a victim and so on, and reparations is concerned. And my young lady from Colombia, I think you also asked a question on gender that might not have been addressed, but I do believe that Francesca tried to say something about this from the point of view of the trust fund. Leo Campo, lastly, I heard you, and I think that the question you raised has to do with monitoring. And as a devoted state party, as you know, Botswana is ready to hear what more can be done, what more we can do within the limit of our resources to move this forward, to make it more meaningful and make our contribution to the Rome Statute scheme more meaningful. Thank you very much.
Yes, thank you. Thank you for adding those points. They were vital. And thank you for the discussion. And to briefly return to Slido and the motion, acquittals are perceived by the international community as failures of the ICC, agree or disagree. It's 2/3 to 1/3. So with that, I will conclude this panel, and I welcome you to take lunch outside, and we will begin again at 1 o'clock. Thank you.